Welcome back to Court Scene TV. Today's case is one that will stop you in your tracks. Imagine this: a woman already convicted of harming an elderly relative, a crime that carries heavy weight in the justice system. Instead of a long prison term, she was given probation, a chance to prove she could turn things around. The court essentially handed her the keys to a second chance at life. But second chances only matter if they're taken seriously. Instead, excuse after excuse began stacking up, leaving the judge and everyone watching frustrated. What was designed to help her succeed became a long list of violations and broken promises that I end this hearing. Emotions boil over. The judge, after months of patience, finally runs out of room for leniency. What led to that breaking point? Missed drug tests, skipped mental health appointments, and even defying orders by reaching out to the very person she was barred from contacting. Each violation chipped away at the court's trust. This case isn't just about one woman's mistakes. It's about the larger battle between rehabilitation and accountability. How far should the justice system go in offering mercy before it has to bring down the gavel? Stay tuned, because what you're about to see is more than a routine probation hearing. It's a dramatic confrontation between a judge determined to uphold the law and a defendant who pushed every boundary of her probation. And when the final decision comes, it lands with a weight that few defendants are ready to face.
I've got 5 more years that I could add on to that. I can give you up to 10. You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I have went to the hospital and everything.
Morning, Mr. Lewis. Thanks for being patient this morning. All right, ma'am, are you Devin Atkins? And Miss Atkins is on probation for the 3rd-degree felony offense of injury to an elderly person. That's started at May 23rd of 2022. There was a motion to adjudicate probation filed. She entered pleas of true to counts 4 and 5. Does the state have testimony with regard to counts 1, 2, and 3?
Yes, the court would like.
Yep, I think I would.
Down there, Cole.
Yes, ma'am. Good morning, Ms. Cole. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Ms. Coleman, would you please state your full name for the record?
Shakita Cole.
How are you employed?
I'm employed at Jackson County Adult Probation.
And as an adult probation officer, is it your responsibility to supervise an individual on this court's probation by the name of Devin Atkins?
Yes.
Do you see Ms. Atkins in the courtroom here today?
Yes.
Can you point to her identifier?
Right here in the blue jumpsuit.
Your may the record reflect Ms. Cole has identified the probationer Devin Atkins.
Record will so reflect.
And Ms. Cole, as with every probationer, when they are placed on the court's probation, are they given the rules and restrictions placed upon them and what they are supposed to do to follow the court order?
Yes.
And each one of those in detail is gone over with them so that they understand everything that they're required to do, correct?
Yes.
Was Ms. Atkins so advised?
Yes.
At her intake?
She was advised at her intake and at a TTM at the Melton Center in person.
Okay, and describe for the court what a TTM is.
A treatment team meeting.
Okay, so in your opinion, Ms. Cole, as her probation officer, was Ms. Atkins fully apprised and aware of what she was required to do on probation?
Yes.
And were in fact a majority of those things intended to help her?
Yes.
Was she advised that she was to report to the Community Supervision Department when directed by yourself and the court?
Yes.
And did Ms. Atkins, based on your review of the file, fail to do that on multiple dates, including but most likely not limited to November 4th of 2024, November 19th of 24, and and was that in violation of her probation order?
Yes.
Did you address that with her and inform her it is important to report if you have something coming up, you need to let me know?
Yes.
And did she do that?
No.
Did you catch that moment? The probation officer didn't sugarcoat a single detail. They laid out a list that speaks for itself. Missed check-ins, unfinished community service, skipped treatment programs, and even failing to provide a verified address. Each one isn't just a slip-up. Together, they paint the picture of someone who repeatedly chose not to comply. That's not bending probation rules. That's shattering them time after time. And here's what so many forget. Probation isn't meant to be a punishment in itself. It's a chance to prove that prison isn't necessary, a structured opportunity to show responsibility and rebuild your life outside of bars. But when someone ignores their reporting schedule, skips drug testing, and abandons their treatment plan, they close the very door that was open to keep them free. This leaves the court in a tight corner. How many chances can be handed out before accountability has to step in? At some point, leniency runs dry, and the only remaining option is a prison sentence let's put the question back to you. If you were in the judge's chair, would you roll the dice on one more chance? Or would you decide that enough is enough?
Was Ms. Atkins, as a condition of said probation, ordered to perform community supervision hours?
Yes.
And to report those to you?
Yes.
Obviously, if you do not know that she has completed them, even if she has, is that a violation of her probation?
Yes.
To your knowledge, based on your review of her file and your supervision of her, did she either complete the hours or immediately report to you? Sorry, I'm reading that. No wonder everyone's looking at me.
I was about to, I know, I was about to,
Well, that is in fact a condition of probation, right? Is it also a condition of probation that she is to report to you as her address and so that you know where she is at all times?
Yes.
And if she does not do that, is it impossible for you to locate her?
That's correct.
Did she in fact immediately report to you her current address?
No, she did not.
Most importantly, based on Ms. Atkins' underlying offense and her issues, was she ordered or did she attend the safety program?
She attended safety. She completed the unit placements and the residential aftercares, but each time that she went for the supported outpatient, she didn't complete. So she didn't continue.
Okay, and was that failure to provide verification of attending safety a violation of her probation?
Yes.
And did that go hand in hand with her failing to successfully complete safety, which is to include any aftercare programs?
Correct.
And she did fail to successfully complete the entirety of the safety program as ordered?
That's correct.
And again, addressing those issues, is she ordered to submit at your direction and court's direction to alcohol and/or drug screening?
Yes, she is.
Was she ordered to do so on October 30th of 24, November 7th of 24, November 12th of 24, and November 13th of 24, and November 16th of 24?
Yes.
And to your knowledge, based on the review of her file, did she fail to do that?
She did fail to do that.
With respect to the entirety of Ms. Atkins' case, if I may, if this is the appropriate time, Judge, is there anything else? I know you and I have had a lengthy discussion about her that you feel would be appropriate for the court to know in conjunction with your testimony and your updated PSI?
The main thing is her mental health. She refuses to address that. We've made appointments for her with Spinaltop and she didn't attend the appointments. She's 100% when she was out unmedicated. So that kind of interfered with her completing her services. And she maintained contact with the victim in the case. So okay. That part, her grandmother was trying to be there for her because of the mental health difficulties.
This is where the case takes a tough and emotional turn. The probation officer testifies that Atkins has flat out neglected her mental health treatment. Missed therapy sessions, no consistent medication, and a grandmother desperately trying to keep things from falling apart at home. It paints a picture not just of poor choices, but of someone slipping further and further out of control from a legal standpoint. This is where the line gets blurry. Mental health issues can absolutely influence how a judge looks at sentencing. The law recognizes that treatment and support matter. But here's the key. Mental health struggles don't erase court orders. If the system offers counseling, therapy, or medication management and the defendant refuses to engage, that refusal counts as non-compliance in the eyes of the court. And that brings us to the difficult question. Should ongoing mental health struggles act as a reason to shield someone from prison time? Or do they instead highlight that stricter measures may be the only way forward?